Something is shifting inside the United States immigration system, and if you have been waiting, watching, and holding your breath for months, you need to hear what happened this week. Because amid all the chaos, all the court battles, all the enforcement headlines, there are real signs of movement, real reasons for hope, and real filing opportunities opening up right now that could change the trajectory of your case entirely. This is not speculation. This is not wishful thinking. These are the facts on the ground as of April 2026, and every single immigrant navigating this system deserves to know exactly where things stand. Let us start with the biggest legal story unfolding at the highest level of American government, because what happened at the United States Supreme Court on April 1st, 2026, sent shockwaves through the entire immigration community. The case is called Barbara versus Trump, and at its core, it asks one of the most fundamental questions this country has ever been forced to answer out loud. Does being born on American soil automatically make you an American citizen? That principle, known as birthright citizenship, has been the law of this land since 1868. It is written directly into the 14th Amendment to the Constitution, passed in the aftermath of the Civil War to guarantee that every person born in the United States is a full citizen, without condition, without exception. For generations, immigrant families from every part of the world built their lives around that guarantee. They came here, they had children here, and those children grew up as Americans. That was the promise, that was the foundation everything else was built upon. The current administration's executive order attempts to dismantle that foundation by stripping automatic citizenship from children born in the United States to undocumented parents. If that order were ever allowed to stand, it would represent the single most sweeping alteration to American citizenship law in the entire history of the country. Research from the Migration Policy Institute projects that ending birthright citizenship could increase the undocumented population in the United States by nearly 25% over the next 50 years. Think carefully about what that number actually means in human terms. Children born in American hospitals, in American cities, in American communities would be classified as undocumented from the very first moment of their lives. But here is what the justices actually said when they gathered to hear arguments. And this is the part that gave millions of immigrant families the first real reason to breathe in months. The court was skeptical, and not quietly skeptical either. Justice Ketanji Brown Jackson questioned directly whether the government's order was even remotely workable in practice, asking point blank whether officials planned to bring pregnant women in for depositions to determine citizenship eligibility before birth. Justice Brett Kavanaugh, widely considered one of the more centrist, conservative voices on the bench, focused his questions on the very arguments being raised by immigrant rights groups challenging the order. That was a signal that the concerns about this executive action reached across the ideological divide. Justice Amy Coney Barrett pressed the administration on whether their legal theory would have applied to the newly freed enslaved people, the very human beings the 14th Amendment was written specifically to protect. Justice Neil Gorsuch methodically dismantled one of the Trump administration's central arguments, the claim that a parent must have legal domicile in the United States to pass citizenship to their child. And Justice Elena Kagan was direct and unsparing, telling the government's Solicitor General flat out that the constitutional clause at the center of the entire case simply did not support the position the administration was taking. ACLU attorney Hannah Steinberg walked out of that courtroom and said the justices had hammered repeatedly on how this policy would even function in practice, expressing deep skepticism at every turn. The Supreme Court has not issued its ruling yet. This case is not finished, but the signals coming from April 1st are the most encouraging signals the immigrant community has received from the nation's highest court in a very long time, and they carry enormous weight, not just as a legal milestone, but as a statement about the kind of country the United States intends to remain. Now, there is a second major story unfolding simultaneously in Washington, and this one is about money and what money controls. For nearly 7 weeks, the Department of Homeland Security operated under a partial funding shutdown. Negotiations between Republicans and Democrats collapsed repeatedly. The stalemate dragged on week after week, and the entire enforcement infrastructure of American immigration hung in a state of uncertainty. Then, in early April 2026, President Trump endorsed a plan that would resolve the shutdown by funding most of DHS through one bill, while channeling ICE and Border Patrol funding through the reconciliation process, a legislative procedure that bypasses the Senate filibuster entirely and can pass with only Republican votes, requiring no Democratic support whatsoever. Congressional leaders, including House Speaker Mike Johnson, confirmed their agreement to this approach. What this means in practical terms is that Republican leaders are now aiming to lock in immigration enforcement funding at maximum levels for the next 3 full years. 3 years. That timeline is not accidental. It means that regardless of what happens in the 2026 midterm elections, regardless of how the political landscape shifts, the funding machinery driving America's deportation and enforcement operations would be structurally protected from legislative challenge for years to come. The enforcement numbers already reflect what that kind of commitment looks like in practice. In January 2026 alone, ICE arrested more than 36,000 people. CBP added another 3,595. Nearly 40,000 individuals were booked into immigration detention in a single month. In Colorado alone, ICE arrests quadrupled compared to the same period just 2 years earlier. And data consistently shows that the majority of those detained carried no criminal record. They were workers, parents, spouses, and longtime community members swept up in enforcement operations running at a scale this country has not witnessed in generations. The human faces behind these numbers are no longer staying hidden in the shadows of policy debates. They are reaching mainstream headlines and forcing a national reckoning that goes far beyond politics. ICE agents detained the newlywed spouse of a soldier who was actively training to deploy overseas in defense of this very country. A 3-year-old child reportedly suffered abuse during months spent inside federal immigration custody. Families that had already been separated during the first Trump administration back in 2018 found themselves detained again in 2026. These are not isolated incidents buried in footnotes. They are the daily documented reality of what mass enforcement at this scale produces on the ground. And they are forcing a conversation not just in the courts and in Congress, but in the conscience of ordinary Americans who are watching it unfold in their own neighborhoods. And yet, in the middle of all of this turbulence, something important is happening inside the legal immigration system that every green card applicant, every employment-based visa holder, and every family waiting in the backlog absolutely needs to hear right now. Because even as enforcement intensifies around them, the official channels of legal immigration are showing genuine signs of forward movement in April 2026. And there are filing opportunities open right now that may not stay open for long. The April 2026 Visa Bulletin has been released by the U.S. Department of State, and it contains filing guidance that could be directly actionable for your case this month. USCIS has confirmed that for April 2026, applicants across all family-sponsored preference categories and all employment-based preference categories may use the dates for filing chart. If you are not already familiar with how this system works, let me walk you through exactly why that confirmation matters so much. The U.S. green card system operates on 2 separate charts. The final action dates chart tells you when a green card can actually be approved and issued. The dates for filing chart tells you something different and often more immediately useful. It tells you when you may be eligible to submit your adjustment of status application, even if the final approval date has not yet arrived for your specific category and country. When USCIS opens the dates for filing chart the way they have this month, it means certain applicants can take that crucial step of submitting their application earlier than they would otherwise be permitted to do. And filing that application is not just a bureaucratic formality. It is a doorway to real practical benefits that can stabilize your life in meaningful ways while your green card case continues moving through the system. Once an adjustment of status application is officially pending, you may become eligible to apply for an employment authorization document, which is the legal right to work in the United States while your case is being processed. You may also become eligible for advance parole, which gives you the ability to travel internationally without abandoning your pending case and losing everything you have built toward. For hundreds of thousands of immigrants already living and working inside this country, these 2 benefits represent genuine stability during one of the most uncertain chapters in American immigration history. The annual limits governing this system remain firmly in place. Congress has set the cap at 226,000 family-sponsored visas and at least 140,000 employment-based visas per year worldwide, with strict per-country limits that continue to create lengthy waits for applicants from high-demand nations. Immigration attorneys are consistently advising their clients that forward movement in 1 month does not guarantee continued progress. Retrogression is always possible later in the fiscal year if demand outpaces available supply. But right now, in April 2026, the filing window is open, and if you are eligible, the time to act is not next month. The time to act is now. There are 2 additional developments inside the legal immigration system that every applicant must understand, and one of them took effect just days ago. Effective March 30th, 2026, the U.S. Department of State dramatically expanded its social media vetting policy to cover more than a dozen additional visa categories. This expansion now includes K-1 fiancé visas, religious worker visas, and visas for trafficking and crime victims. Under this updated policy, applicants are required to disclose every single social media account they have used in the past 5 years. They are expected to make their profiles publicly viewable throughout the entire processing period. Immigration attorneys are issuing urgent warnings that failure to disclose any account, even an old one you barely used, even one you consider insignificant, or choosing to make a profile private during processing, could result in serious application delays or outright visa denials. If you have a visa application pending right now, or you are preparing to file one in the coming months, you need to conduct a thorough audit of your complete social media presence today. Every platform, every account, including ones you deactivated years ago but never permanently deleted. The government will be looking, and anything they find that you did not voluntarily disclose will be treated as a red flag that puts your entire application at risk. The second development affects skilled workers on employer-sponsored visas and deserves close attention in the weeks ahead. The Department of Labor has proposed a significant overhaul of how prevailing wages are calculated for H-1B visa holders and workers in related programs, including H-1B1, E-3, and PERM. This proposal, if implemented, would change the salary thresholds that employers must meet to legally sponsor foreign workers across these categories. It has not taken effect yet and is still moving through the regulatory process. But for the hundreds of thousands of skilled workers whose legal status in the United States is directly tied to employer sponsorship, this is a development that demands attention right now. If wage floor requirements increase significantly once the rule is finalized, some employers may make the calculated decision not to renew sponsorships, and that choice has direct, immediate consequences for the immigration status of the workers they currently sponsor. So here is where everything stands as of April 2026. The Supreme Court appears poised to push back firmly against the administration's attempt to end birthright citizenship, offering a potential landmark victory for immigrant families and for the constitutional framework that has protected them for over 150 years. DHS funding is being resolved in a way that will entrench immigration enforcement at historic levels for years to come, regardless of future elections. ICE is arresting tens of thousands of people every single month, including individuals with no criminal history. Social media vetting has expanded to more visa categories than ever before, creating new compliance obligations that no applicant can afford to ignore. And yet the April 2026 Visa Bulletin is open. The dates for filing chart is available for both family-sponsored and employment-based applicants. Cases are actively moving through the National Visa Center. Consular processing is running at embassies and consulates around the world. The legal pathway to permanent residence in the United States has not been closed. It is narrow. It is crowded. It moves slower than it should, but it is open. And for those who are eligible right now, this month's window may represent one of the most significant filing opportunities of the entire year. Stay informed, stay compliant, stay prepared, work with a qualified immigration attorney who understands every change happening in real time. You came to America because you believed in something worth believing in. Do not stop now.